Welcome back. Thank you very much. We still have our expert, Professor Kommal. Thank you so, so much. What I wanted to ask you, because we as an attorneys, we are not doctors, we are not experts. The client log in our offices and ask, I suspect that I have a negligence, a medical negligence, because my father went to the hospital, he never came back. He was very healthy when he got to the hospital. So I want the doctor to give an example or the easy way to be able to identify this is a possibility of medical negligence.
Sure. Thank you, Mr. Kgaka. Before we get into an example, I think what's important to identify is to draw a line between medical experts whose intention, and there are a large amount of them in industry, whose primary purpose is to assist the court, provide the facts, their experience, and what they have for the purpose of the court to make that decision. It's not their decision to make. They can make recommendations. But as you will rightly point out, the discretion of the final decision is in the hands of the forum and the judge or the presiding officer in that matter. Because that's contrasted to hired guns. And I mentioned this because there was a judgment that I went through yesterday by Judge Fisher, in which a particular colleague, another professor in a clinical domain, was heavily criticized. Because this colleague had then, and to draw an inference on that, had said that because a patient has some superficial scarring on the face, it will result in lifelong pain and disfigurement, and the pain is so debilitating due to some scratches on the face, he will lose a future income of 2 million rand, which the doctor had no scientific basis to make. And that is where you need to understand where your limitation is. Because there are times, and you and I know it well, when a law firm says, you work for me, you'll do what I tell you to do. You will sing for your supper. And I've had large clients with the organizations we work with, I meaning the businesses I worked for and represent, where I've walked away and said, I'm sorry, my integrity is not for sale. I will help you in a case where the evidence is in that direction, where we can find something. But we're not going to lie blatantly, because that's your hired gun, and it's a slippery slope. So when the viewers try and assimilate this, don't go in the perspective where a lawyer will tell you, I'll get a doctor to say this, because it's a dangerous slope. And I've met the regular colleagues who've built very big names in the medical legal world, and that's how I built my reputation. I went against them in many matters and said, your science doesn't make sense. A journal article from 1969 is long outdated. A article reference on something outside of your domain because your wife's a psychologist has nothing to do with you. Limit yourself to what you know. And I'll give you an example before we demonstrate some of the negligence cases, and something you've probably seen a lot of, given your extensive expertise in the medical legal world in the personal injury space. An orthopedic surgeon will say, because the patient has lost X degrees of range of motion of his ankle, he cannot bend his ankle so much. That we know, because you can measure that. It's a scientific fact. But then he goes further and says, because his ankle can't move arbitrarily by 4 degrees, that will result in his loss of work capacity by 13.2%, which means he will lose out. It's hogwash, for want of a better phrase. Because orthopedic surgeons, and this is where the establishment comes from, the HPCSA says as a medical practitioner, all specialists are medical practitioners first. There's no field of expertise. You work in a specialist domain because you're an expert in that and you've trained in it.
I see.
But you're still a medical practitioner. There is the profession of medicine. In the profession of medicine, it says do what you've been trained in. And training in what is recognized. Which then means an orthopedic surgeon is bound by the syllabus of what he was trained in at the university in his master's degree or at the colleges of medicine for his fellowship. And they've trained in all of the medical fields, and I can assure you, work functionality and work capacity is not what orthopedic surgeons are trained in. I've had heated discussions about that, but the facts are clear. Having trained in the US, what we've established, and we know that in South Africa, the domain of rehabilitation and physical medicine, which is where all of this falls in, and a field that I've been working for the last 10 years, is known as physiatry, or physical and rehab medicine, PMR in the US. It's a specialty. South Africa closed its register in the 80s. Most likely, based on my research, every specialist who trained in that field is now dead. So there is no specialist. So what happened is the orthopedic surgeons then had what they called self-created scope creep. So they would say more than they could, but who would challenge them? Because everybody had a handshake deal to say, you say it, I say it, the courts don't know different. Then you had the occupational therapists, who are therapists, they're implementers. They're not primary diagnosticians, who would then traverse in the field of physical medicine. Yes, they work as part of the rehabilitative team, but originally, therefore, they were not known as clinicians. They are therapists. They implement the treatment plan. They can make some level of diagnoses, but that needs to be confirmed by the clinician again. But in South Africa, over the last 25 years, because the physiatry or PMR specialty has fallen away, you now have two fields that have no formal training in this crossing that line. Yes, there is a master's degree that the OTs do now, and they do some work in vocational and all of that, that's implementable. But it doesn't tie into the clinical domain, which is where the gap is. So when you look at examples of negligence, I've had cases, as I mentioned earlier, a doctor operated on a patient. But it was clearly substandard to anyone, even a general practitioner who doesn't operate regularly, who's trained in orthopedics, that a wound involving a joint needs to be adequately explored, as we call it, and debrided, meaning cleaned surgically in theater, because you need to know if there's damage to the bones, there's damage to the capsule, the joint contents, and many other related complexities. That was an obvious case. There are cases where the line is blurred, and I'll mention one without mentioning the patient's details. I was called by a learned colleague of ours who was a judge, he's now a silk, who does a lot of extensive training, and his focus was this patient, yes, the patient had with a kyphoscoliotic spine, so meaning a curved S-shaped spine, so the child was bent to a large extent, but he was mobile, he could walk. Went to a government facility, and the facility promised the family they would operate and straighten his spine and improve his outcome and quality of life, which made perfect sense. Except the patient went to theatre and came out, and obviously the family being lay people in the healthcare world, he came out paralyzed. He couldn't walk anymore. He was in a wheelchair.
That is a clear example of medical negligence, yes.
Absolutely. But here was the question. What happened? The senior counsel had sent the records. I had studied it in detail, and I got back to him and said, they write based on their response, because the response in the claim was the surgeon did nothing to the spine. Based on the records, the surgeon didn't touch the spine. So yes, they started the operation and realized whatever the factors were, they're not going to carry on. They canceled the operation and moved on. But given my experience in anesthesia, I then told him, yes, they're right, the surgeon didn't do it, but the anesthetist did. Like, but why? And without going into a lot of technical detail, we established that there was some negligent conduct by the anesthetist during the surgical process, because they're working together at the same time, that the spine was damaged and there was significant impairment. When direction changed on the negligence, saying, yes, we know you as the state are liable, yes, it's not that doctor, but you as the state collectively are liable, the matter was eventually settled out of court. But it's knowing how to understand the evidence. So in summary, my suggestion is, if a matter comes to an attorney, and with great respect, there are amazing attorneys and advocates who have extensive experience, bring the file to someone, I wouldn't say me, but one of the key services that we offer in our organization is what we call a pre-screening. We don't want to take your money and charge you huge amounts of work and in special investigations if we're not sure, do you even have a case to start with? The intent is to help you and your client. As a service provider, our aim is to give you the best possible science, but also protect you and your client and the funds. So we would then charge per unit of time, depending on the volume of records, to study the records and give you a 1 or 2 page summary saying, based on what we've studied, this is what I found on the records. It could point in this direction, and if you want us to go in that direction, you need to make the decision as the lead in the legal matter. Do you want to invest? We cannot promise you what that special investigation will find. For example, if it's a brain scan, I don't know what we'll find. We think there's something, but until we do it, we don't know. The alternative is we'd look at it and say, we don't think so. But if you want to run with it, we'll run with it, but we're not going to give you guarantees. So it depends how much, as a legal practitioner, you want to invest in the matter. And that's a gamble you've got to take, a calculated gamble. But the evidence must support your claim. You cannot have somebody coming in, and I'll give you a loose example on that we spoke about earlier, where a rider of a quad bike crashes his quad bike into his bucky on his farm and then sues the state for negligence. I looked at it and I laughed. But here's the problem. The fact that he broke his ankle, whether the state was liable or not, I had an opinion. I put it there and qualified it, saying it's not my problem. The legal team must deal with the merits. But from the clinical perspective, there is a broken ankle, and the state must decide if it's compensating. This is what we found. And myself, supported with my orthopedic team, together with everyone else that was involved in the assessments, we formed a collective opinion individually and shared the evidence and went in a direction. What was perturbing is the patient had an explicit recollection of what happened, demonstrated by his accident record, or the accident report. It's demonstrated by the medical records. His GCS was 15 out of 15. He could tell you everything in clinical detail what happened. And then you get a neurosurgeon who's now stopped practicing for 20 years, who comes out of the left field with a 100-page report with a diagnosis, and I'll never forget it because I challenged him. He said the patient has a mild but significant traumatic brain injury with significant neuropsychological features. It's a mouthful, and I said in my report, I want to challenge him on the stand through the team, because one of two things happened with this neurosurgeon. Either he made a scientific breakthrough that is so cutting edge that nobody in the medical world ever found it before he did in terms of that diagnosis, or he was lying. And the reality was he was lying, because he had never done a brain scan, the history didn't correlate, and the first 5 pages of his report said, on a neurosurgeon's assessment, I found nothing. But because a relative of his, without mentioning that, is a neuropsychologist, he will extrapolate an 80-page discussion of things completely outside of the field of a surgeon, and then infer the findings that were not made already supports a finding of a brain injury. And I said, but hold on. Where's that person's opinion who's trained in that domain? And in summary, he actually withdrew in the matter. He's one of the biggest and most, I would say, arrogant but strongest names in the industry. Nobody challenged him. And I said, I'm sorry, my colleague, the evidence and the science doesn't support you. Don't speculate. He withdrew on the matter. But I'm not saying I was right alone in the matter. My focus and advice to everyone is, when you deal with negligence matters or personal injury matters, or anything involving healthcare professionals, if they give you a predetermined outcome, they are hired gun. If they are willing to investigate and look at other things, then they're probably doing their job well. Because even as a legal practitioner, you need to understand, if a doctor, and I won't speak for others, if I, for example, told you, Mr. Kgaka, you say the patient has a cognitive fallout. What is his HIV status? Is he diabetic? What are the underlying factors? What is his performance prior? If you get upset if I ask those questions, then you don't trust my judgment. Because the intent is to establish that 1 in 5 in South Africa has HIV. And HIV encephalitis and cognitive impairment is found in a lot of those patients without your injury, without your claim. We've then got to rather investigate and establish these things, because you'd rather hear it from me as an expert providing input into your matter than your opposing expert catches you out in court when they're opposing the matter. So it always helps to say, let's not make unrealistic promises to the client, but tell them we'll do the best we can given the resources and given the science available at that time.
Wow, wow, wow. Without any doubt, you can see that medical negligence is not a child's play. You need an expert. Thank you very much, Prof. If you have any medical negligence that you are suspect, you can see that at ES Kgaka Tennis, we will go a long way with you. We'll make sure that we get an expert like Professor Kommal, and I think he's the right person to be consulted. Thank you very much.